good morning. Welcome to our live immigration attorney chat. My name is Attorney Vanessa Ruiz, and this is our weekly live chat where we have different topics, keeping you up to date with the latest immigration news, and also just kind of going through some of the questions that a lot of people have. If somebody has had that question before, most of the time you have as well, or somebody else that you know does. So that's the point of these Facebook Lives. We just really like to kind of interact with people as much as we can and spread some good information. So for those of you who are new to our Facebook page or to our firm, we are Immigration for Couples, and we're dedicated exclusively to helping couples navigate the U.S. immigration process. So it's something that is not always the smoothest. It's sometimes a little bit bumpy, takes a really long time. And so that's what we're here for, is we try and take away that stress from our clients and from our couples. And we assist them, we assist people across the nation, across the world, everywhere. So we're here to just help make people's lives a little bit easier, especially with something that can be very stressful and definitely something that impacts a lot of people's lives. So today I'm going to be discussing a particular kind of waiver. So for those of you who follow our Facebook Lives, this week is waiver week. Attorney Desiree kind of gave a general overview in the last video about waivers and essentially how to set yourself up for success. She kind of went over different types generally and what they really kind of are for. But today we're going to talk specifically about one particular kind of waiver, and it's one of the ones that we encounter very often, and it is called the I-601A Provisional Waiver. And so a lot of people ask, how do I know that I need a waiver? How do I know what I need to provide to win the waiver, to get approved for the waiver? That honestly is going to depend on the reason why you're requesting a waiver. So as Attorney Desiree mentioned in her overview of waivers, each waiver is essentially there to cure a certain ground of inadmissibility, meaning there's something that will not allow you to become a permanent resident in the U.S. because of XYZ reasons. So it could be criminal grounds, it could be unlawful presence, it could be drug usage, things like that. You just never know. Immigration histories, if they're complex, if people have been in removal proceedings before, all those are reasons why someone might need a waiver. But each waiver is going to target something specifically. And so one of the biggest misconceptions is that a waiver is a waiver is a waiver, period. And that's not true. There are many different types of waivers, and each one is specifically for some specific issue. And so we have seen a lot of people who try to do things themselves and will submit what they think is what the waiver that they need. It turns out they end up getting denied. They lost time, they lost government fees. And so in order to avoid all that, it's better to get a legal analysis on your case specifically. A lot of times people think that maybe they don't need a waiver. They think, oh no, my case is easy, it's clean. It's really not. You never know what could trigger a ground of inadmissibility. And so the legal analysis and having a consultation with an attorney and having an attorney walk you through the process and help you through the process really and truly is invaluable. So before we start talking about the provisional waiver in specifics, I think we need to have a little bit of a history lesson. The provisional waiver is essentially pretty new. It came around in 2016. And so in the immigration world and with general rules and laws that date back decades, I mean, that's a baby. So this provisional waiver is still a baby in a sense that it only came around within the last decade. And so before the provisional waiver came around, if anybody had any kind of unlawful presence, so time in the U.S. without permission, so if somebody entered the U.S. without permission, or if somebody entered with permission, entered lawfully with a visa, maybe a tourist visa, a student visa, a work visa, anything like that, and they overstayed the time allowed. So essentially, if they were given 6 months on a tourist visa, Starting 6 months and 1 day, if you did not leave, you are accumulating unlawful presence. And so in the past, if people had unlawful presence of more than 6 months, they were deemed inadmissible. But especially for those people who were going through consular process, most of the time they didn't find out that they were inadmissible until they actually either went to their interview in their home country, or if they had previously been in the US, left for their interview, and then they were told, oh, I'm sorry, you're inadmissible because you were there for over 6 months, you were there for over a year, things like that. And so what happens was they created this provisional waiver for those people who specifically are in the US already. And so most of the time, the people who are going to be eligible for this waiver are those who are consular processing, meaning that they have to return to their home country to actually get their interview done and get approved outside of the US. So this isn't for people who are adjusting their status in the US. It's for those who are eventually going to have to leave. And it's for people who are already in the US or still in the US after having been admitted lawfully or having entered without permission. And so this particular waiver is one of the ones that's most talked about in a lot of immigration groups and when you research, because it applies to a lot of people who are already in the US. And so we just like to kind of give that warning to say you need to be able to qualify for this waiver to go ahead and do it in the US. Not everybody qualifies for it. Not everybody needs it either. So definitely just trying to get an analysis on your specific case is going to help you a lot. But essentially what this provisional waiver does is if somebody is in the US and they have more than 6 months of unlawful presence, so like I mentioned, either they entered the US without permission and they've been here since, or they entered with permission, overstayed their time by more than 6 months, and are still here, and they are going to consular process, so they're being petitioned by somebody, and eventually will have to leave to go do their interview, this waiver could be available to this person. Now, this particular waiver only cures one ground of inadmissibility, and that's the unlawful presence. And so if there's any other kind of issue, if there has been, some kind of misrepresentation or fraud, if there's been any kind of alien smuggling, meaning you brought over a family member with you without permission, if there's been any kind of criminal issues that need to be waived, things like that, this waiver will not cure any of that. And this waiver actually should not be requested if you have other issues as well, because this waiver is supposed to be for one thing and one thing only, and that's for that unlawful presence in the US, and that is it. And so essentially the way we see this waiver a lot is when somebody is being petitioned for either by usually a spouse, a child, a parent, things like that. It just depends on the situation, but essentially they are in the US, they've already been petitioned, that petition has been approved, and now comes time to apply for the consular processing. And so essentially, right before they leave for their actual interview, we want to make sure that that person has a provisional waiver already approved. And so there is a specific timing, there is timing that needs to be taken into consideration. There's timing that needs to be kind of matched up with when they're going to leave, because all this needs to be done before they leave. And the reason that it's called a provisional waiver is because it's a temporary grant. Essentially, it's not final until the person has been approved at the consulate. And so the reason that's why it's provisional is because it's kind of it's a placeholder, it's temporary, it is approved before you leave, but essentially what they're saying is that the consular officer has the final say. And so at the consular interview, that officer could revoke the approval. And if there's any, normally it's going to happen if there's any other kind of ground of inadmissibility. And that's why I said if there's any kind of misrepresentation, fraud, criminal issues, it's best not even to request this waiver, because what's going to happen is you're going to invest a lot of time, effort, money, government fees into this waiver, only to have it revoked when it comes time for the actual interview. And so that's why we say, it cures one thing and one thing only. And if you have anything else, it's not for you. So essentially, it's provisional, like I said, because the consular officer could decide at the end there is another ground of inadmissibility, and because of that, we're going to revoke this approval because it was a provisional approval, and now we're going to request that you seek a different kind of waiver, and the waiver needs to include XYZ grounds of inadmissibility. So that's what makes it provisional. And so one of the keys as well to this waiver is that you have to have a qualifying relative. Now, the way that the rule for this waiver is written is that a qualifying relative can only be a resident or citizen spouse or parent. And so it cannot be children. A lot of times, people find themselves in a difficult situation where they don't qualify for this waiver because they don't have the qualifying relative. So again, that qualifying relative, the kind of key to being able to request this waiver is going to be a resident or citizen spouse or parent. And so children, again, do not count. I can't tell you how many cases, consultations and people that I've talked to who are like, I don't have a resident or citizen spouse or parent. I only have a U.S. citizen child, and that child is the one who's petitioning for me. And unfortunately, that person does not qualify for this waiver because children cannot be included as a qualifying relative. Okay, so that's one of the keys as well. So the next part of it is not only do you have to have that qualifying relative, but you have to be able to prove that that qualifying relative, so your U.S. citizen or resident spouse or parent, is going to suffer extreme hardship without you. What does extreme hardship mean? Extreme hardship is, it's an ambiguous type of term because it's like, well, what rises to the level of extreme? And that is going to be determined on a case-by-case basis. So another reason why you definitely want to have an attorney helping you with this is because no two waivers are the same. I have done hundreds of waivers throughout my career, and honestly, none of them have been the same. A lot of them may follow general types of patterns, but none of them have been the same because everybody's life is different. And so extreme hardship to your spouse or parent who's a resident or a citizen can be proven in multiple different ways, just depending on the situation. If you have older parents, a lot of times, it's going to take into consideration the fact that they need help, they need additional care. They may have health issues. You might be their financial provider, things like that. And so a lot of times that's what happens with older parents, but not always. Sometimes it can be the spouse for this exact same reasons. If somebody has, extreme physical conditions or needs certain types of treatments or medications, it can be not only physical, but it can be mental and emotional. If people are suffering from anxiety, depression, different types of conditions, if there's medication being taken, if somebody has, a severe financial need and that person definitely needs the help of their partner or of their child, if you're using the parents, it can be financial, emotional, medical, all of those things. And so a lot of times we tackle one because it's the strongest one and we include information about the rest, or sometimes we kind of give them a general picture of this is this person's life and this is why they need to be able to be in the US with either their spouse or their parent, because that person is going to suffer extreme hardship if their spouse or child, in that case, were not in the US in order to help them. And so, there's a lot of factors that go into it. There's a lot of details, a lot of strategy. And so, again, like I said, each case is different and each one requires an individual analysis just because no two cases are the same. And what made somebody else's case strong may not be the strongest point for you, but you might have something else that somebody else doesn't. So super, super important to keep that in mind, that it's not really a cookie cutter type solution. Each one is done individually and each one it should be for sure determined, for the strength of that case. So And that's generally what the provisional waiver is. Like I said, just to kind of give a quick rundown, it's for people who are in the US who have some kind of unlawful presence of more than 6 months. It does not apply to people who potentially have been coming in and out of the US without permission, staying for certain times, leaving. It may not apply if, even though people are entering lawfully, they've stayed long times, left, come back. These are all really things that need to be analyzed and determined before filing any kind of waiver. And so, it may sound like it applies to you, but it may not in the long run, or you might think I don't need it, but it turns out you do. So, like I said, and I will keep saying in all of my videos, having that analysis from an immigration attorney who has the experience and the knowledge is going to be invaluable. I promise you that. I've had many people who, like I said, have filed waivers on their own thinking, from my research, I think this is what I need. And it turns out that it wasn't at all. And just another key thing about the provisional waiver as well is that it takes a really long time to get approved right now. Unfortunately, once the pandemic started, it was one of the ones that I don't know why specifically, but has been affected the most by the wait times. And so in the past, before COVID, it might have taken 9 months to get one of these waivers approved. Now we're sitting at 2 years. And so you don't want to file something that you think you qualify for without getting analysis, only to find out 2 years later that you didn't need it or that it was the wrong type. And so I'm going to talk about different kinds of waivers throughout tomorrow, and then starting again on Monday of next week, we'll be discussing other types, but essentially get legal advice always to see if you qualify for a provisional waiver, to see if you need a provisional waiver, and if you do, to determine the best strategy. So like I said, it is an investment of time. It's sitting at about 2 years right now. There is a government fee that's associated with it. And what you don't want is to waste time that you didn't need to, or to essentially be told later on this waiver is not strong enough, we're going to deny it, and when you could have done it right and could have done it strong from the beginning. So that is generally the provisional waiver. There's a lot more to it though. So if you need some help, as always, you can visit our website, immigrationforcouples.com, schedule a consultation, speak to an attorney, because nothing is ever going to beat that. So for those of you who use different kinds of social media, please share this video across Facebook, across other platforms, and that way people can get good information from it. So thank you for being here today, for watching. If you're watching on replay, feel free also to leave us comments as always, letting us know if you have any questions, and it might be the subject of another video later on. So I hope you all have a great day.